Good morning. Good morning. Good morning.
Good morning.
We're back. Light on Suitability's back after some hiccups, absences, people moving on, a lot of people moving on. Daryl and Sean are doing excellent. They've moved on to greener pastures and they're doing great. And I'm back with Joe. I think Michelle has started up a nonprofit for her dog rescue program. And so everybody's doing really well. But I have had a lot of interest in the program through the emails. And so here we are. We're back. I'm back with Joe, and we're back with an important topic. How are you doing today, Joe?
Oh, doing great. How are you doing?
Mm-hmm. Yeah, doing great, doing great. It's good to be. I like this show. We tried to do the 5 o'clock, but for some reason, it just never worked out for people. And then also I hit a snag through football season, Sundays and football. And it just, I don't know why. We just, it's been since May, maybe we posted a show. Then I had Christina helping me. But anyway, again, a lot of very, very nice emails from family members. I even got an email from someone from, I think the state was Minnesota, asking me questions. If I have time, I'll go to those emails today and maybe we can take a look at those, Joe. But I wanted to talk to you about this latest, greatest snafu that's happening with our clients with respect to restitution. And so I'll just give a background and then we'll get started talking about it. But sure. What happens to our clients is if they owe restitution, the state, they have a trust account in the prison. And so families and friends can send them money so that they can go to the canteen and buy a pad of paper, a better quality toothbrush, a better pair of shoes, just different little things like that. Okay. Chocolate bars, everything else. Everything is provided for a client in prison. They get, toothbrushes and soaps and things like that, but it's very minimal and it's a very, they get a cafeteria. They can go to the cafeteria 3 times a day, the meal and things like that, but it's not great quality. So if you want to get like Starbucks coffee or something, you buy it at the canteen. Okay. It's not a Starbucks coffee. It's like the ground up coffee and you can buy a little package of coffee. Actually, I think I'm getting that wrong. I think families can send that in, but at the canteen, you might be able to buy like a chocolate bar, a pad of paper, a pen, and things like that. Maybe you know more about that. But anyway, so families send money in. And then if you owe money, the state or CDCR, the state, on behalf of the state, CDCR takes 55% of whatever money is sent by the family or friend and puts that toward the restitution bill owed by the client. Okay. And so what people do in prison is they have a scheme. So they tell their families, and even sometimes the families, they say, I don't want to spend my 55% on restitution. We'll get into that as well. But so they'll send it to a different inmate who doesn't owe restitution, and then that inmate will filter it through to the client for a payment, not a 55% payment, sometimes like a 20% payment. So, or if they don't owe restitution, then they'll take the money and they'll filter it out. And so it's many different things. It's many different violations of the prison rules and just ethically violating many different things, in particular unauthorized business transactions, and the money that you get is supposed to be the money that you spend. And it can create controversy. It can create issues with a whole host of things, which we will elaborate on. So with that kind of intro, what add to that, Joe, for anything I've forgotten? You got to unmute. You unmuted so that you wouldn't make noise.
Yes, that was very good, and that's all correct. It's either somebody who owes restitution and they have their family or who's ever sending them money put it on somebody else's books who does not owe restitution, so that money is not taken out, and then that person whose books they put it in gets, a percentage of the money, a fee, like you said, 10-20%. So that's number one. And number two, if somebody does not owe restitution and they're going to a hearing, but they let somebody else put money on their books, yes, that's also a violation, because they're circumventing the process of restitution, which obviously is a negative, a big negative. And as it goes further, it's disrespect for the victims, for the process, for lawful conduct in the prison environment. They're breaking the rules, and the commissioners and the BPH have picked up on this, and it's one more reason to deny parole or to pull a grant of parole from somebody who's already received one if they discover that person has been breaking the rules. It goes back to a nexus of criminal thinking in the eyes of the board, which I guess, they have a point.
100%. So let's talk. I want to definitely expand on that just a little bit more in a minute. But what has been your experience lately, Joe, with your clients and some of the commissioners that you've encountered with respect to this issue?
Yeah, obviously it's not seen in a good light. They tried to question the inmate as to how recent the violations have been. If it was, 10 years ago, I don't think it matters as much because there's such a distance of time between the act. However, if it's been in the last 5 years, and especially in the last year or two, it's, to put it mildly, it's frowned upon. So that's my experience. And they use it to deny parole to people. Like if somebody is like just kind of on the cusp, that gives them one more reason to feel they have solid ground to deny parole. Yeah, it's used as a reason. It's used as a reason to deny parole, and it's it's not very pleasant when you see somebody who's been working hard otherwise, programming and following the rules, and then to come up with that, it can be very frustrating, even for the attorney or for the inmate. Absolutely.
Yeah. What has been your experience with respect to the timing, the distance needed when you might not have had had any examples yet, because this is really, they just started doing this first thing in January-ish, kind of noticed it in December. What kind of distance do you need from that behavior?
Well, ideally, I would say at least 5 years. The more, the better. The more time between doing that and going to a hearing, you want to have as much time as possible. If, like, say, you did it back in the fall or something, last November, last July, within the last year, that's a negative. That's a big negative.
Yeah. For sure, a big negative. So what I found is took a while for the commissioners to get ramped up. I had a week of hearings where the commissioner said, we've been ordered to ask everybody, and then didn't ask any of my clients. It didn't end up mattering because my client who got granted parole, I knew that he told me, and then I believed him. So that was that. But anyway, that's my job, is to believe my client.
Sure.
And then one panel tried to ask everybody, and then my next week of hearings, what I was doing is I was offering my client, if I knew that there might have been some restitution issues and they were going to be either granted or paroled, I took a break and asked them, okay, how do you want to do this? Now, they haven't asked you, what do you want to do? If you get granted, there's going to be an investigation, which I should elaborate on. And if they, if they are going to deny, maybe you just want to put this on the table so it's, done and dealt with before the next one. So I did that. I had a hearing week with a certain commissioner. We won't get it. It doesn't matter about who it is or who it isn't. His style was, if he was leaning toward granting, and you can get a sense, you and I both know, you kind of can get a sense of how it feels, how it's starting to feel. He would ask them. If he wasn't going to grant parole, he wouldn't ask them. And so interestingly enough, on a guy that he didn't ask, when it came my turn to ask questions, I took a break because I said, okay, well, darn it, he's not granting you parole, I don't think, because if he was going to grant parole, his style was to ask you the question just to make sure that everything's covered. And the client said, and then we talked about it because maybe the dust will settle in a year and a half and that issue will kind of fade away and people will have stopped doing it as much. And maybe, the investigations won't continue or whatever.
Mm-hmm.
That client, we decided not to do it. And then he granted parole. So we have an issue there coming up. So what they'll do is on that date, supposedly, they're going to investigate. Well, I've tried to figure out how they would investigate this. So they're going to pull his trust account probably, and then look at who's sending in money or not, I guess. Or I don't know how they would figure out to have if families were sending it to some other inmate. I guess they could connect his family list to the other inmates' trust account, but then how would you discover the trust account that the money was given to? So there's definitely some ignorance from us, meaning we're not sure of all the information. I don't know if ignorance is the right word, but I think it is, on how that investigation would take place. And then whatever they discovered, they could then listen to phone calls in and around the time or at any time. And now that they have AI, they can easily just search, probably just search a whole bunch. I had this guy who did EDD fraud, and, sometimes clients, they have a hard time accepting responsibility. Let's just say that. And then I got the 115. It's like a 20, 30 page 115 with a 115 being a write-up. They call it a write-up. It's a report of a rules violation. And it was 20 pages of his conversation with his loved one. And wow, that conversation. I think the conversation hurt him more than the fraud, because he didn't even get any money. But the conversation he had with his loved one demonstrated a lot of lack of insight into domestic violence because of the way that conversation had gone. And I won't get into too many details just because I don't want to, I don't want to get too up against the attorney-client privilege line, even though I haven't mentioned names. But it just was, that was an issue that came up behind this EDD fraud. EDD fraud, the reason why I think they discovered EDD fraud, or the restitution issue, was because the EDD fraud, they were investigating for sure. And then they started stumbling across these patterns. And so that's how the restitution thing came. And also people after years and years and years still owing a lot of restitution after even having a job. Even though it doesn't pay that much, it still makes a dent after a little bit of a dent, at least after 20 years. You can see if, that's happening. So I'm not quite clear on the investigations. Any thoughts about how they might be investigating that, Joe?
No, that's a good question. And I've kind of explored that in my mind, at least. That is tough. And not only how they investigate, but the number of investigations that they'd have to do because, you know, with however many hearings they have every week, doing the math, they can't look at everybody's trust account. So, maybe they're investigating some and not others. But regardless, we don't know that. And so, as we always advise our clients to tell the truth, uh, that's a tough one. How they're gonna investigate. I'm sure their internal affairs has been working overtime or whatever uh, to investigate. All they can do is take the trust account and see who's put money in, how money has moved, but the specifics are tough because we're not there.
One of the things that triggers an investigation is the grant of parole, is what the commissioners are saying. So if you get granted parole, they're saying, okay, and then they ask, well, the legal department is that will trigger, supposedly supposed to trigger the investigation. So I guess they would do a preliminary, pull trust accounts, try and cross-reference family members, if they can try to cross-reference a family or friend that's connected to, how our clients have something in their central file where there's a list of approved family members, friends that are allowed to send money or mail or whatever. You have to be approved first. You can't just send stuff to an inmate. The inmate has to say, yes, I want that person to write me, because otherwise it would just be harassment city from the public or whatever for some of
Sure.
these people. So they want to make sure that that's permitted. And then there's no issues with family where you're not supposed to speak to a child, for instance, and that sort of thing. So they control that process. So maybe they would cross-examine that, or cross-reference then. And then I guess, I don't think, if the guy says, and he's honest about the restitution and said, yeah, I was doing that up until about a year ago. Sometimes if you already have other deficiencies in your program, i.e. you're lacking, whatever it is you're lacking, insight is a big one. You're usually not denied for no vocational skills, generally not denied for that. So generally it's either insight or recent misconduct. Insight being a very broad topic. They will say, okay, you put that on the table, and that's probably tabled at that point. Since you were honest, you've already, what do they call it in the hearsay code? Like self-incrimination or something, declarations against interest. So they're probably going to say there's a reliability there and go, oh, okay, he's admitting he's doing it. And so the next hearing, that's probably good. We're fine on that guy. But it's the guy that says, no, I've never done it, and then gets either denied or granted. So at the next time, if you say you didn't do it because you were going to get denied, and then at the next hearing, everything's kind of cleaned up, and then they ask you about restitution and you say, yes, I did it. And then you say, well, you lied at the last hearing. That may create an issue depending on the time. And he could just say, and then he has to go back to criminal thinking topics of discussion and that kind of thing. I haven't had anybody denied solely because of that. And I haven't had any grants of parole where it went south because the client was very honest. I've had one where the client was very honest. It happened about 2.5 years, 2 years. They granted him. He was honest and they granted him. And then he said he remedied it in a certain way. And we can talk about that, how to fix. I've had guys, yeah, I was for sure doing that. And when was that? Last time was about 2019. Fine. That's a grant of parole. Honesty and enough distance. So they're probably looking at about 1.5 years-ish. This is no rule of thumb. This is just based on a few weeks of hearings from all of us. Attorneys try to argue I think at one of the roundtables, I don't know if you were there, but attorneys tried to argue, okay, so they did it and it's recent. Now what? And then attorneys try to argue, well, it's not really their money. And to be honest with you, I find that I guess it's the best argument that they have, but with respect to the money is given to the inmate. So it's the inmate's money. So it's just the same as like, oh, okay, well then, the family's sending in money and the inmate's using it for heroin, cell phones, etc. So to say that, okay, it's not their money when they send it, it's his money to use as he sees fit because they send it and he uses it for heroin and cell phones, but it is their money if they send it and he's going to use it for something legitimate. I don't know if that argument passes I don't know. It seems like lacking maybe it's some kind of a double standard. I don't know what I'm trying to say. Do you
Yeah.
understand what I'm trying to say, Joe?
Yeah, I think I am. I hear inmates saying, "Well, that's my family's money. It's not mine, so I don't want them, taxing my." They don't say it in those words, but taxing my family the 55%. Because that's their money that they're giving to me. So that's their argument that they're punishing the family and they're not punishing me. But at the end of the day, actually it is their money when it goes into their account because they're using it for whatever purposes, hopefully to buy things at the canteen.
Right. Or whatever. Yeah.
Yeah.
And also it just, it's just you're committing a crime with your family on top of it now. And now this family member or this friend is the one that's going to write you a letter later. And so if it's been a family member knowingly giving you money to use 45% of it to buy heroin, okay, right? And they knew all along, your credibility in your letter of support is also diminished. So that's tricky, and it is whether you want to circumvent the restitution because it's your money or not, meaning you, the family member, it's hurting. It's hurting your loved one's chances of being paroled. It's hurting your credibility in a letter of support. It's engaging in criminal activity and we learn in criminal thinking, criminal gangs anonymous, gang mentalities, 2 or more people engage in criminal activity in the prison world. So really bringing up a host of things there. So not a good issue. There's some arguments that, victims aren't even getting the money. I just think that's a red herring on this issue to use that as an excuse, not a good argument to use at your hearing, that the state is mismanaging the funds or anything like that. Not your business, not your concern. We don't know if victims aren't getting their money. That's between the victim and the state. A lot of times the victim has to take proactive steps to get the money. They're not going to look for the victim to give them money. Unfortunately, maybe the system is a little dysfunctional, but again, using that to excuse the behavior, very risky strategy at a parole hearing, because then you're going to get dinged with lack of accountability, lack of remorse, lack of empathy to victims, lack of victim awareness, lack of victim impact, internalization and stuff like that. So very, very not a very tricky argument.
Yes, all of the above, and like you said, including you're re-victimizing the victim. You don't have good victim awareness, and it shows disrespect for the victims as well. So yeah,
In particular, if you've got victims sitting in the hearing with you, and you're admitting to, which is fine. If you admit to it and it was 5 years ago, but again, it's just you've engaged in this activity, so stop it. so that you can say, I realize it was wrong. It's affecting the victims. The victims are sitting there going, wow, you're cheating me of my funds, potentially, and whatever, because all of that will just be fall back on the taxpayers as well. So that's a victim of this scheme as well. So
Mhm.
even if the family's 55% is taken to pay into the victim restitution fund, we as a society may end up footing that bill anyway for all of that circumventing. So I just wanted to say too, maybe this is a little more controversial, but also a lot of family members are the underlying reasons why a person strayed and went off into criminal activity. And we talk about that a lot as causative factors. So when you have family members that perhaps didn't have, you have parents that just didn't have a good handle on they didn't have good parenting skills. Let's just put it that way. And so your kid, for whatever reason, was running amok in the streets and all of that. We talk about that at parole hearings as a contributing factor. We're not allowed to blame the parents, but I'm just saying for then that parent or loved one to say, well, I shouldn't have to contribute. I'd question that from a more morality point of view as to perhaps everybody needs to give back here to the system. That's we create this cycle of violence, and there's a lot of dysfunctional families. I'm not blaming it on the families or anything else. I'm just throwing it in there as that other thing that floats out there at these parole hearings, and it does. And we're very careful about talking to our clients about it's never your parents' fault. But when you're looking at this victim fund and who should pay, should society pay because family members that were dysfunctional at the time of their loved one's life crime were sort of dysfunctional and not really supporting their child as well as they should have, and maybe later in life got it together, recognized the harm caused and whatever, and then they want to make it right themselves by making amends, by not continuing to victimize the system. I don't know if I've said that very tactfully, but it isn't, it's something I've considered. It's just something I've considered.
Yes, of course. And also too, this was their family at the time of the commitment offense, and so there's that. And then if the family has contributed negatively, like say for a while the inmate used a cell phone, and now they're trying to circumvent the restitution, it like gives them zero credibility in those support letters, like you said, or for parole plans after transitional housing, because obviously you don't want somebody moving back into the household. They always ask about, are there guns in the household? Is there alcohol in the household? But then having somebody who's contributed to the illegal activity in prison, it's cell phones,
Mhm.
maybe,
And we're talking knowingly. We're talking knowingly.
yeah. Oh,
You're
absolutely.
being an enabler. I'm not talking about you
Yeah,
said money and your loved one was lying to you about, "Oh, yeah, I'm using the money to buy candy bars at the canteen," or whatever. Knowingly
sure.
sending money, or should have known perhaps saying, "Hey, mom, I need 500 bucks." It's like, I don't know why you need 500 bucks. There's only so much you can use it for at the canteen. You
Right.
may be on notice a little bit unless you're completely naive to the system. But
Yes.
then I would say, you know, we know.
Yeah, well, the cost of coffee and the ramen noodles, they've gone up, but not that much.
Not that they're pretty pricey too, but still not. You should be sort of a red flag if your loved one is asking you for too much money, too
Yes.
much money. And then they're also getting write-ups, visits are being canceled, things like that. you're now on notice that something's might be fishy about the requests for additional funds. But that's just a side thing. That's
Right.
not anything to do with the restitution necessarily. And also asking, questioning, you should have been questioning, perhaps, unless you're really naive, why the money is going to some other inmate's account. That should be a red flag as
Yes,
well.
absolutely.
As
Yes.
well. And if you're encouraging it, if you're saying, I'm not sending you money because they're going to take my 55%, it's like, well, you were going to part with that $100 anyway. So what difference does it make to you other than you are hurting their chances of being found suitable for parole if you enable that or encourage it or say, I won't send you money unless you tell me I can send it to John Smith, who doesn't owe restitution, and you'll get all the money. But again, you're not getting all the money. You're getting 20% of the money. And you might be creating controversy, which might get you in a fight, might get you, someone dropping kites on you or whatever they call them, confidentials on you because they got mad because you didn't give them all the canteen or, they made off with the money. It's not good. It is not good. It's not good. What can you do? What do you do, Joe? Your client, you sit down with your client, you're talking about all the different factors of variabilities, the stuff that you would like to see them doing, and then you come across, you say, oh, let me ask you about this restitution thing. And they say, okay, yeah, I did it 5 years ago. Or yeah, I just heard about it and I stopped doing it last month. What is your
Hmm.
go-to suggestions for that, your advice, your counsel?
Well, it's tough, but I tell them to tell the truth because sooner or later that's going to catch up with you. And if you get a grant, they're going to look at your account, your trust account. The chances are they're going to look at it very closely with this being a hot button issue today, especially. So at some point, I believe they're going to find out they have the resources to do it. So even though it's tough, I tell them to tell the truth. I tell them if they're doing it to stop doing it. And we can only take it from, from today, from this moment forward. We can't change it, whether they've done it 2 or 3 months in the past or 5 or 6 years ago. So wherever you're at, just stop it and move on. And enough people do that, it's not going to be a big issue in the future, but everything takes time.
Yeah, everything takes time. And so, yeah, if it's 5 years ago, making sure that make sure that they have, sorry, at a minimum, victim impact / awareness, criminal thinking. They've done more work on character defects behind that behavior. Make sure that, it's kind of hard on the family member letters, just, watching the language in those letters saying he's been a
Oh,
model inmate and things like that. Just keep that out.
yeah.
Just provide letters about support
Hmm.
overall and concrete things that they've done that you've noticed a change in them and stuff, and being very careful, probably having family members review those letters. Our attorneys review the letters from family members to make sure there's no language in there that could be used against the person at the parole hearing, because you will have some panel members saying, have you finally told your family what it is that you did to get you in prison? Have you told your family that you were using heroin for the last 20 years and their money was involved? Have you told, have you told them? When did you tell them? When did you tell your gang that you were done and all that stuff? They love those questions because the
Yes.
when is related to the distance for the commissioners. So
Hmm.
make sure they get lots of program. If they've done it recently, then you've got a larger strategic play. And, if they done it recently and have recent write-ups, it's probably better to just there's two ways of going about it, and just taking your lumps now and potentially facing a 5-year denial.
Hmm.
which is tricky, right? It's tricky to get that 5-year, even if you can petition to advance and or waive yourself to some clean time, but make sure that your loved one talks to an attorney before that psych eval, because that psych eval could come out very negative and then you're stuck with it for 3 years. So you really want to strategize in case the forensic psychologist ask your loved one about restitution issues. If you're totally free and then all of a sudden the board says, okay, ask them about restitution. So far, I have not seen that happening. But again, if you get the grumpy commissioner that thinks you should have stipped or whatever, and then you get nailed with a 5-year denial, remember that 5 years is 5 years unless you can petition to advance. And if you have one intervening snag, you're doing the whole 5 years, because your petition to advance will be denied, and then you only get one every 3 years. So it'll be a very tight walk for you to do, because you certainly don't want to come back from a 5-year denial before like the very earliest 1.5 years, very earliest. I usually say 2, because they're sending a message. 5 does not mean 5 may mean 3, but 5 for us doesn't mean 2, because otherwise we might have denied you 3. So you could come back in a 1.5 years. So it's just a tricky thing that definitely you need to work it out with your lawyer on that front. But definitely boning up on all of those areas, all the character obviously greed, selfishness, criminal thinking, all of that comes up. But be prepared to discuss all of those character defects behind it and acknowledge the wrong, understand the harm. And this thing, like, here's another thing I get, Joe. I didn't know it was wrong, but I'll talk to other clients who will say, yeah, I knew it was wrong. I found out it was wrong. I went to victim impact 3 years. When did you stop? Oh, when I went to victim impact or victim awareness, and they said, and then speakers came, or we were taught that the victim restitution fund plays a role in making amends, which is an important part of steps 8 and steps 9. And as you know, the commissioners love the 12 steps. So if you're doing this restitution thing right off the bat, you're not practicing step 10, you're not practicing steps 8 and 9. You're not being of service to others, you're not being honest, you're devastating all of your work that you've done for the last 5 to 10 years on those steps to get yourself in a position to be found suitable, and you've just washed it all away. So to say I didn't know, if you have any history of taking victim impact, probably in person, you've probably learned that restitution is not good. And if you didn't stop, then the commissioners are going to point to that other client that sat before them and said, well, I learned that in victim impact, and to stop it. And then if you have family members if you say to your family member, I can't do this anymore, it's illegal, it's immoral, it shows a lack of disregard for the feelings and rights of the victims, etc. And then you have a family or loved one that says, well, then I'm just not going to send you money. Okay, well, then you have to think about that issue from that standpoint of, well, are they really the best person then to support you out in the community? Because they're not willing to, they're an enabler. And you really need all the help you can get on the outside from people that are pro-social, like very pro-social.
Yes.
So that was, anything else on the victim impact? It's a pretty big deal right now.
Yeah, no, I think you covered it really well. It opens a whole Pandora's box of a number of issues related to criminal thinking, which you touched on very well, regarding victim impact, victim awareness, victims being compensated, making amends, understand the nature and the magnitude of how the victims have been harmed, and then circumventing that. So, yeah, you said it very well, Elizabeth.
We just before we wrap up,
Mhm.
I had some listeners. I don't know if she wants to. She just said it's from the Vijay family. I'm a current listener. I found your podcast helpful. I gave it a 5-star review on Spotify. Thank you so much on
Mhm.
that. I hopefully she can find the show on YouTube. I might get away from Spotify. I'm not sure. I'm not sure if it has the best reach or not. She started listening 2 weeks ago, binge listening, and she said her loved one is enrolled in a lot of programs and so on. So, in terms of being able to help anybody, you know, that would depend on one, we're state appointed, so we get appointed as the state sees fit on a rotational basis and or accept retained cases that way. That's about as much as I'm probably permitted to say on YouTube. But I should probably let her know that we're over on YouTube. Now I think it's going to have a better reach. And then Suzanne Brent is from, I think she said she's from New York State, New York Parole, New York. And no, Mrs. Massachusetts. Joe, you were born in the United States. MA, the state MA.
Wow. I think it's Massachusetts. Yeah, because Maine is ME and MA is Massachusetts, I believe.
She's asking if people can parole to a home with guns in the house. Unlikely, but all I would do is I would check with the parole agent.
Absolutely.
And that way, that police officer, family member may have to, maybe the parole agent says, I just can't see a parole agent saying yes or no. What do you think, Joe?
Well, I think obviously one of the conditions of parole would be no weapons, whether they're firearms or knives or whatever. I don't see that happening. Think about it. In a civil society, that a felon or an ex-felon should have weapons and access to weapons in the household. I mean, that's just how the law is. I think anywhere you go.
I just don't even think, like, even if he wasn't a police officer, like, say I was the lawful gun owner, I had all the licensing, I did whatever state was, required by the state to get that gun.
Hmm.
I just don't think I could have a parolee living with me. I don't think the distinction is that he's a police officer. I just gives you access to the weapon and you're a parolee. I just don't think so. I'm
No.
thinking no. I'm thinking no, but this is just my random opinion based on no. I'm not licensed in Massachusetts. I'm not licensed in New York. I'm only licensed in California. I don't even know that answer for California, like black and white, but my common sense says not gonna be permitted. And if it is, you would have to go heavy scrutiny with the parole department, and maybe you just need to call the parole department and ask them. You might get more answers there. And I don't know if Massachusetts has parole lawyers that help you over there, but neither Joe nor I are licensed in Massachusetts or New York, and we are not permitted to give legal advice. So this is not legal advice. This is just brainstorming on options for you. Perhaps call the parole agent, but I would suspect no. And is that really a good idea? I know you trust your loved one and everything not to do what he or she's not supposed to do, but I just think not a good idea.
I agree 100%. Yeah.
Yeah. Yeah. And
And just
really
use
think
common sense. Just using common sense, even without the law. And you
just use
want,
common sense.
yeah,
Antisocial personality disorder. Almost every one of our clients is diagnosed with antisocial personality disorder.
sure.
Are you cured from mental health disorders in general in life? No, you're not. you're either in some kind of a remission and or you have learned how to replace your behavior with certain coping strategies. But the fact remains, just like an alcoholic or a drug addict or any other addict, that you are always at risk for relapse into whatever disorder that it is, substance use disorder, sexual addiction, blah, 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 right? And so therefore, think about it, antisocial personality disorder. If you're just always at risk to reoffend. I'm not trying to hurt anybody's feelings. I'm just saying that because you're never found to be a no risk to reoffend. It's always high, moderate, or low. And even though the risk of reoffending is quite low, in particular in this state, and that's largely due in part and due to the commissioners heavily scrutinizing who they grant parole to and the high standards that they have and the requirements that they have to, before they put their name on a grant of parole, that you have a very solid understanding of how you are going to navigate around your antisocial personality disorder, your substance use disorder, your XYZ disorders. Okay. And so again, I don't know that it's a good idea to have a parolee living in a house on parole with a gun accessible. I just don't. And police officers, man, they get weird when they know there's guns in a home and there's a parolee there. They're just, and very fairly so. Okay. I'm a police officer. I don't want to walk into a house where a parolee has access to a weapon. I don't want that.
No.
Sorry to be very conservative, but I always err on the side of being conservative because that's what wins the day at the end of it when we're trying to get people released and staying free and not being violated.
Yes, absolutely. You don't even want to go there, to having a gun or anything that's questionable like that.
Abundance of caution. I mean, maybe you just need to, I don't know how a police officer has to have the weapon on him, but maybe he just has to lock it up. If he really wants that parolee to live there because he's being very supportive, maybe he just needs to lock it up at the station and then he just goes to the station and he gets it. I understand, you're vulnerable, I suppose, but I don't know. That's just my naive brainstorming about that issue.
Yeah. Well, I would err on the side of no weapons, no drugs, not even any alcohol,
That's the other thing. It's like, well, I drink. I only drink a beer and I'm not going to have a whole booze case filled of booze. But if one of the issues is substance abuse, you have to live in a sober house. Yeah,
that's just the way it is, that's how it is.
It's better, especially when they identify triggers and stuff as being around people who are drinking and that sort of thing. So I don't know. Please just use an abundance of caution. Talk to your potential parole agent department and go that way. Talk to a lawyer. If you can get a lawyer, hire a lawyer. Hire a lawyer in Massachusetts. Pay a lawyer to give you some advice. They'll usually give you first 30 minutes free. Sometimes, even if they don't, just pay them for the advice.
Yes, absolutely. I mean, it'll be money well spent.
Because I'll tell you, the commissioners that we appeared before, if they said, "Oh, you're going to go live with your brother who's a police officer," oh, okay, police officers have weapons. Is that a good plan? Is that a realistic plan, Mr. So-and-so? We don't think so. You better go and rethink that plan. Denied until you come up with a better plan. That's probably what would happen in California. What do you think?
Well, not exactly, because they say that you can never be denied for not having parole plans or transitional housing. So that's the one hand. They may ask you to rethink it. And plus, they're going to be speaking with DAPO if they're granted parole to be in a place that's appropriate. But I would think having a member of law enforcement in the household is a positive, because we perceive that as the member of law enforcement walking the straight and narrow. I mean, they can't stray too far. They're tested for drugs, I'm sure, occasionally, or if there's some kind of reasonable suspicion. I don't know. I wouldn't go that far.
Yeah, we're
But
not sure about, but probably they've got to live a pretty clean. You're supposed to.
yeah,
There's always a bad apple here and there, but
right.
I just don't know, Joe. I just don't know. I had a
Mhm.
guy denied. They denied him because of his parole plan, saying that he was going to check with his children to make sure that the victim of his crime, which happened to be his ex-wife, wouldn't be at the soccer game. And they said, oh, okay. So you're going to use your children to find out where your ex-wife is. And, it's a domestic violence case. And they said denied. I was floored. So now,
Oh,
every
yeah.
time I have an experience, I'm thinking, okay, more abundance of caution is needed on these. Didn't think about it. We didn't think about it, and it sunk his boat.
Oh, man.
Mm-hmm.
That's harsh.
I was pissed off, but because
Yeah.
you could have just told them, oh, don't do that. We're going to grant you. Please don't do that. That they wanted him to spend 3 years thinking about why that was a bad plan.
Uh,
And as it
that's
turned out, the wife wasn't even living in the state. They gave him a hypothetical. So he gave him the hypothetical answer. And then that was it, done. Not a big fan of that commissioner, but that's okay. That's okay. That's okay. What do you got planned for next week? What's coming up?
actually, I have a couple hearings. I have one of those weeks where you have, two people.
Mm.
Actually, I started with 5, but some of them waived,
Mm-hmm.
and one of them got a private attorney. So, yeah.
Okay. Yeah, I've got to do some in person, Avenal in person,
Okay.
Tuesday, Wednesday. Well, I guess I shouldn't announce where I'm going.
It's okay. It's okay.
Never mind. Nobody's watching. Yet they'll probably watch the recorded show. So that's good.
There you go. Yeah, you could edit that out.
I'm so lazy. I never edit anything out.
Huh.
I'm not necessarily lazy, but I just don't. My editing skills are poor.
Uh-huh.
Very poor. It'd be nice if maybe StreamYard had an editing feature, but they don't. Next week, think of something interesting to bring to the table. One of the things I wanted to do is I was going to go over lots of problems with commissioners, clients, and so on, thinking that they have to admit to guilt for certain things, agree with the official version to be found suitable. So I was thinking of bringing in a couple of really important cases to discuss about that.
Okay. Mm-hmm.
And how we approach that at our hearings, and really give you positive stories, because I have gotten a lot of grants of parole on clients who have not admitted the crime, said they didn't commit the crime exactly the way they say they committed, misidentified as the driver, not the shooter, not the driver, all kinds of different scenarios.
Yes.
Was one of them. And if I get more consistent on YouTube and we have more viewers, then they can always chime in on a live stream and ask questions on the fly.
That'd be great. Yeah.
Yeah. I really appreciate you coming on today, Joe. And where can somebody, the 2 people that liked our video, the 9 subscribers, how can they get a hold of you if they have questions or need help with parole?
Sure. Yeah. My email is jrhaytas, HAYTAS, at haytaslaw.com, or they can call me on my office line at 909-912-0190.
Perfect.
And I'd be happy to answer their questions.
And or
Which,
throw your questions in the
which,
comments below, and we'll
yeah.
try and take a look at those
Hmm.
as well. I know that people tune in a lot after the fact. They don't always subscribe or like, but if you could subscribe or like, that would really help us just get more traction. I do include the podcast link or the podcast logo thing on the brochure I send out to the prisons. But other than that, I really don't have a really great reach. But I know that people do listen. Family members of my clients do tune in from time to time.
Sure. Great.
Yeah.
Great.
Yeah, you should share the link as well, Joe.
Oh, absolutely. Okay.
Okay, well, you get better, and we'll see you next week, hopefully.
All right. Sounds good, Elizabeth. Thank you.
Okay. See you,
Okay.
Joe.
Okay. Bye now.